Hello, good afternoon, all. I hope I am audible. So, in the previous classes, we have discussed about Unit 1 and Unit 2, that is the basic of company, the meaning of company, and also incorporation of a company. Also, we have discussed about the prospectus. So, in Unit 3, today we will be discussing about memorandum and articles of association. So, without wasting time, we will start with the Memorandum of Association and Article of Associations. Well, a company is an artificial legal person created by a law. Since it has no physical existence, it can act only through the documents that defines its objectives or its powers, rules, as well as internal management. So these foundational documents are two foundational documents are there for this purpose. The first document is Memorandum of Association and known as MOA, whereas the second one is Article of Association known as AOA. So both are mandatory documents for incorporation under the Companies Act 2013 and together form the constitution of a company. Now, coming to Memorandum of Association, the Memorandum of Association is the charter of a company. It defines the scope of activities, powers, and relationship of a company with the outside world. So basically, it lays down the boundary line beyond which the company cannot operate. Now, talking about the legal definition of MOA, Section 256 of Companies Act 2013 define memorandum as memorandum means the memorandum of association of a company as originally framed or as altered from time to time. So this definition is in from the Companies Act 2013. Do mention the legal definition whenever you are writing answer for memorandum of association. Now coming to the importance of MOA. The first thing it defines the area of operations of the company. Then it protects shareholders by ensuring funds are used only for authorized objects. Then it protects creditors as well by informing them about the company's powers. Then it acts as a public document available for inspections. So it is uh, transparency is there, so that's why they're saying that the document is available to general public for any purpose, for inspection purpose, to get to know the terms and condition and whatever the objectives are there for MOA. Then lastly, it established the company's legal identity is only established by MOA. So MOA need to be clearly defined, so that's the importance of it. Next, what are the clauses of MOA? We'll get to know now. So, under Section 4 of Companies Act 2013, the MOA has these kind of clauses. The first one is the name clause. So, this clause states that the name of the company, that is, private company, must end with private limited, and if it is a public company, then it must end with a with only limited term. So private company, the term is private limited, and public company, the term is only limited. Let's say ABC Technologies Private Limited. So that is a private company. Also, the company must use its full name in all legal documents. So the reason being it prevent any kind of confusion, identity confusion it may prevent. So that is the importance of name clause. Second clause is registered office clause. So it specify the state in which the registered office of the company is situated. So let's say the registered office of a company will be situated in the state of Telangana. So registered office clause is important. Also, it defines the jurisdiction of registered office clause. Also, it fixes place for legal communication and notices. For these purposes, registered office clauses importance. Next, the most important clause is object clause in MOA. What is object clause? So it defines the purpose for which the company is formed. So why a company is being formed, that need to be defined under object clause. Now there are two types of object clause. The first one is the main object, and second one is incidental or ancillary object. So the main object defines primary business activities, whereas incidental or ancillary object define activities supporting the main objects. Now, let's take an example. To manufacture or to sell and to export any type of electrical appliances, all the activities incidental there too. Okay. Now, there is one thing which is known as doctrine of ultra wires. What is this? So, if a company act beyond its object, such acts are ultra wires. That means beyond power, and those acts are wired. Okay, so there is one case law regarding doctrine of ultra wires in Ashbury Railway Carriage and Iron Company Limited versus Rich in 1875. The company entered into a contract beyond its object. So that's why the House of Lord held it void. So that is the meaning of term doctrine of ultra wires. That comes under object clause only. Now the next clause is liability clause, the fourth clause. So it specifies the liability of members. What are the various types of liability clause? The first is it is limited by shares, then it is limited by guarantee, and it has unlimited liability. So three liability clauses are there. Also, the liability class of members is limited to the unpaid amount on shares held by them. So that is liability clause. Next is capital clause. So it states the authorized share capital of the company. Let's take an example. Uh, like the authorized share capital of a company is 10 lakh divided in 1 lakh equity share of rupees 10 each. So that is capital clause, authorized share capital. Also, it is very important because company cannot issue share beyond authorized capital without alteration. So that is the importance of capital clause. Then the last clause of MOA is subscription clause. So it contains detail of initial subscribers who agree to take shares. Let's say Mr. A has taken 1,000 shares, Mr. B has taken 1,000 shares. So these are the subscriber who sign in MOA. So that is termed as subscription clause. So that was about uh, what were we discussing? The clauses of MOA. Now, the next one is alteration of memorandum. So, MOA can be altered, but only by strict legal procedure as it affects outsiders. So, the examples are uh, name change. So, it is done by central government approval. Or when we talk about object clause, so it is a special resolution. And if we are talking about capital clause, so it is an ordinary resolution. So these are some alteration of memorandum. So that was all about the meaning and contents of memorandum of association. Now we'll discuss about articles of association. Okay. So the article of association contains the rules and regulations of internal management of the company. Coming to the legal definition of AOA, Section 205 of Companies Act 2013 defines it as article means the article of association of a company as originally framed or as altered from time to time. Okay. Now, article association is important because it governs internal administration, the one thing. Then it defines rights and duties of members as well as directors. Then it regulates your day-to-day functioning. Also, it provides flexibility for internal changes. So these are the basic importance of articles of associations. Now coming to the content of AOA. What things AOA cover? The first thing is issue and transfer of shares. Then share capital and variation of rights. Then calls on share, general meeting and proceedings comes under this, appointment and power of directors, voting rights, also accounts and audit, your dividends. Also very important, winding up procedure are also content of AOA. Okay, 1 minute, please. Yeah. Now, coming to the next topic under this memorandum and articles, we need to understand the relationship between MOA and AOA. So, the Memorandum of Association, MOA, and AOA together constitute the constitution of a company. Okay. They are closely interrelated and operate in harmony, though they serve different purposes. Okay. So their relationship cannot be understood by there is a very thin line between the difference between the two. So one by one, according to the features, according to the basic, we'll get to understand them. So the first thing is MOA is supreme, whereas AOA is subordinate. That means MOA is a supreme document of the company, whereas the AOA is subordinate to MOA and deserves it authority from it. So if there is any conflict between MOA and AOA, the provision of MOA will prevail. So that will be higher. That's why it has been said that MOA is supreme. Don't scribble on the screen. If you want to ask, you can unmute and ask anything if any doubts are there. Yeah. So if MOA authorize a company to issue only equity shares, then but the AOA permit the issue of preference shares, such articles will be invalid because MOA has already authorized. Then AOA cannot issue. So that you can quote as an example. Now, according to the next basis, we have AOA cannot go beyond MOA. That means AOA can only regulate matters within the scope of MOA. It cannot enlarge, it cannot restrict or override the object or powers stated in MOA. So let's say if the object clause of MOA restrict the company of manufacturing textiles, the AOA cannot authorize director to start a real estate business or some other business. So they have to stick with manufacturing textile business only because it is being mentioned in the object clause of MOA. So AOA cannot go beyond MOA. Now, the next basis is MOA defines external powers AOA regulates internal management. That means MOA govern the company's relationship with the outside world. Who comes in the outside world? There are shareholders, there are creditors, and third party. Whereas AOA governs the internal management of the company. Who comes in internal management? The directors, the members, the meetings, and voting rights. Thus, AOA operates within the limit of MOA. So that was the third one. Next is alteration of AOA must be consistent with MOA. So AOA can be altered by passing a special resolution. However, such alteration must not be inconsistent with MOA. So there was a case law, Allen versus Gold Reef of West Africa Limited. The court held that alteration of article is valid only if bona fide within the powers of memorandum. So that was the case law related to this. Next basis is MOA act as foundation, whereas AOA act as superstructure of MOA. That means the MOA lays down the fundamental condition of incorporation, whereas AOA build upon this foundation by providing detailed rules for day-to-day administration. So, in simple language, it can be understood like MOA is like a boundary wall of a house, while AOA is the internal arrangement of rooms. Yeah. Now, public notice to board document. That means both MOA and AOA are public documents filed by the registrar of companies. So anyone dealing with the company is presumed to have knowledge of both, but they may rely mainly on MOA for scope of powers. So these are the basis on which you can define your answers. And I'll say if you prepare this portion from this unit, this relationship between MOA and AOA, you will clearly write any answer which is coming from this unit. So this is very important. If you study from this unit, the relationship between MOA and
Excuse me,
AOA,
ma'am.
yes,
Yesterday also this subject only, ma'am.
yes, the subject only.
Okay, okay. Yesterday I didn't attend, so that's why.
Yesterday nobody attended. I was in surprise why no one has attended the class yesterday.
Okay. This is Commerce-12, I think.
This is company law.
Company law. Okay.
Yeah, actually, there was some misunderstanding in the beginning. I was being allotted the financial market paper as well as company law paper. So they have given me from university only. I have got this some discrepancy in the links. So that's why this happened. So previously, I have dealt with financial markets. I hope few people have attended those class over here.
No, ma'am.
And nobody
No,
has attended financial markets.
no, ma'am.
No, ma'am.
I can see few names or repetition. Why I do not know why they're not speaking up that they have attended the class. Um, Anyways, no issue. So previously we have dealt with financial markets, and now we are dealing with company law. Company law is your subject.
Yes, ma'am.
Then study. What's the problem?
Actually, same link, same timing. Another link also we will have, ma'am. That one also our subject only. That is banking law. And I joined that link. There is
Mm,
no, no class, no running the class. But same time, same link. I'll join again this link. Subject
uh-huh.
is.
Yeah, even I am confused with the link scene, but right now I have been allotted this subject with this link. Currently, I got this subject and this link. So whatever information I got from the university, I'm following that thing currently.
Yes,
And
yes, ma'am.
moreover, it is your company law is your core subject, so there is no harm in listening the class.
Yesterday, ma'am.
Anybody? Sorry.
Yesterday, about yesterday, ma'am.
No, no, today I'm saying yesterday also the same class I have taken the same
Yesterday
time,
we don't
same
know,
links.
ma'am. Actually, means
That's what. That's what why do I don't understand why this is happening this time. Since beginning, there is some problem with the links and the schedule. It has even I'm confused. So I have taken clarity yesterday, and I have taken the link and the subject. So it has been allotted. So that's why I'm continuing this. So yesterday also I have discussed the same subject, and coming Saturday, Sunday, 2 more weeks, we'll be discussing this subject only. Same time, same link, company law.
Okay.
Okay.
Okay. Hmm.
Okay. And moreover, it is your core subject, so I hope nobody has any objection in listening.
Ma'am, I'm comfortable with Telugu. Shall I talk once?
Dear, I don't understand Telugu. If you
Okay.
want to, yeah, tell me if you want to share anything. I'll try understanding. थोड़ा बहुत
యాక్చువల్‌గా
आता है.
యాక్చువల్‌గా ఏంటంటే ఫైనల్ ఇయర్‌కొచ్చేసరికి ఫిఫ్త్ సెమ్ కంప్యూటర్ బీకామ్ జనరల్ అండ్ బీకామ్ కంప్యూటర్స్‌కి
हम्म
ఎలెక్టివ్ ఎలెక్టివ్ బి అని సబ్జెక్ట్స్ చేశారు మ్యామ్ ఏ, బి అని. సో
हम्म
మేము బి వచ్చేసరికి మాకు బ్యాంకింగ్ లా ఉంది, కంపెనీ లా ఉంది. సేమ్
हम्म
ఇలా ఈ రోజు షెడ్యూల్ ఏం పెట్టారంటే ఇవాళ లింక్స్ ఏంటంటే ఏబి 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 అని పెట్టారు. కామర్స్ 11 10
या
11 12
ओके ओके
జాయిన్ అయితే మ్యామ్ ఇప్పుడు 12 సబ్జెక్ట్ ఇది కామర్స్ 12 అన్నమాట. సో 12 కి ఎట్ ఏ టైం బి మాది కోర్స్ బి అన్నప్పుడు మేము బి జాయిన్ అయితే బిలో ఏం
हाँ
లేదు.
हाँ
ఏ వచ్చేసరికి
हाँ
మాదే బ్యాంకింగ్ మీరు చెప్పే కంపెనీలా మాదే, బి వచ్చేసరికి
हाँ हाँ
బ్యాంకింగ్ మాదే. అట్లా ఒకటే టైం కి టూ
हाँ
క్లాసెస్ పెడితే మేము ఏది జాయిన్ అవ్వాలో కూడా అర్థం అవ్వట్లేదు మ్యామ్. యాక్చువల్ గా నిన్న
no
మిస్
so if you you must be having elective A or elective B, so whatever elective you have chosen you can join accordingly.
మ్యామ్ సేమ్ ఎలెక్టివ్ బి ఓన్లీ, బట్
Mhm.
ఎలెక్టివ్ బి బట్ దిస్ వన్ క్లాస్ ఇస్ ఎలెక్టివ్ ఏ, బట్ దిస్
uh,
సబ్జెక్ట్ మైన్ ఓన్లీ.
this is that's what I'm saying, company law is your core subject. So listen to this class I'm saying right now. If other links are not working, don't worry about them. This is your core subject, so listen this to this
మ్యామ్ దట్స్
class.
వై
Okay.
యాక్చువల్ గా నిన్న మేము మిస్ అయిపోయాం మ్యామ్ క్లాసెస్ చాలా. నిన్న టోటల్ వీక్ నిన్న మొత్తం క్లాసెస్ మిస్ అయిపోయాం.
uh-huh.
మీరు ఇప్పుడు నిన్న
Oh,
ఆల్రెడీ 2 యూనిట్స్ చెప్పేశారు. మేమేమో ఆ
what
లింక్
subject do
జాయిన్
you
అయ్యాం.
want? What subject you are talking about right now? What subject you want?
మ్యామ్ బ్యాంకింగ్ ల్యాండ్ ప్రాక్టీస్ బిజినెస్ కమ్యూనికేషన్ టుడే ఓన్లీ స్టార్టెడ్, బట్ ఎస్టర్డే ఆల్రెడీ యూ డన్ నో మ్యామ్ 2 యూనిట్స్.
Business, business class, business communication, same time.
ప్రీవియస్ క్లాస్ మ్యామ్ 10:30 to 11:30.
Yeah. Business communication was a Temina madam have took the class. Business communication.
మీన్స్ నిన్న నేను జాయిన్ అయ్యాను మ్యామ్, బట్ ఈ క్లాస్ నాకు తెలియదు.
Yesterday, I told you now. Yesterday there was some problem with the link and the information,
ఎస్
so it
మ్యామ్.
was some miscommunication was there.
ఎస్ ఎస్ దట్స్ వై వి ఆర్.
So for this company law, yesterday, see, listen here. Yesterday we have same time, same subject. Saturday also, yesterday also I have taken 2 units. Now I am continuing same subject with the same link, and coming 2 weeks, Saturday, Sundays, and Saturday, Sunday, 4 more classes to go. I will be dealing with the same link, same subject,
ఓకే
company law.
మ్యామ్. షూర్.
Okay, so you all people join accordingly.
ఓకే మ్యామ్.
Uh, and moreover, it is a core subject, so all good. Okay.
ఓకే మ్యామ్.
Any other question, anybody?
Ma'am, important questions.
After completion of class, in the last class, we'll discuss important.
Okay, and share notes, madam.
Yes, I'll share.
PDF. Last time also this one, yeah, thought about principles of marketing, I think.
No. Marketing is not my subject. I have not taught marketing. I have taught financial markets. Last week, last Sundays and last to last Sunday and then Saturday, Sunday, I have taught financial markets. I have shared notes as well. Anyone having elective financial markets here?
నో మ్యామ్.
Nobody. Okay. Cool. So everybody is having company law as core paper. All participants.
ఎస్ మ్యామ్ ఐ హ్యావ్.
So okay, good. Continue with that. Notes and important everything I'll share in the last class. Okay. So and moreover, you people are having notes with you all. So I hope that is not an issue. Give me a minute, please. Okay. Coming to doctrine of constructive notice. So a short answer might come on this. Let's understand the meaning. So basically, the doctrine of constructive notice means that every person dealing with a company is presumed by law to have knowledge of the content of a company's public document, especially the two documents, the MOA and AOA. That means every person dealing with the company is presumed that to have knowledge of the content of company's public document. These documents are basically filed with the registrar of the company known as ROC and are open for public inspection. Therefore, if even if a person has not actually read them, the law assumes that they ought to know their content. So in simple word, we can say ignorance of a company's constitutional document is no excuse. Like if you are dealing with a company and you are coming up and saying that I do not know this was the clause, so law will not accept this statement of yours. They'll say if you are part of the company, that means you have ought to know about MOA and AOA. You ought to know the clauses. You ought to know the objectives of the formation of the company. So the law will not give you any excuse that you do not know about it. So that is the meaning of doctrine of constructive notice. Now, on legal basis, the doctrine is based on the principle that these two documents are MOA, AOA are public document and anyone can have an inspection of it. Hence, outsider are deemed to have constructive, that means implied notice of their content. Now, what comes under the doctrine? What is the scope of doctrine? The doctrine applies to the power of the company, then the object of the company, then authority and limitation of directors, and lastly, the procedures which are prescribed in the articles. So an outsider must ensure that act that they are entering into it within the object of the company and in accordance with the AOA. Let's say if AOA of a company states that all contract above rupees 5 lakh must be approved by board of director and a person enter into contract of 10 lakhs with a single director without board approval. So the company is not bound by the contract. So even if the outsider was unaware of this restriction, the law presumed that they knew it. Okay. Now there is one case law also, which one a leading case law regarding this, which is Kotla Venkateswamy versus Ram Murthy in 1934. The articles require that all deeds should be signed by the managing director, the secretary, and a working director. So a deed was executed with only signatures. So what was the judgment which was passed? The court held that the company was not bound as the outsider was deemed to have constructive notice of the article. So that is this. Now, you should also be knowing about the effect of doctrine. That is, it protect the company from unauthorized act. Then it places responsibility on outsiders to examine MOA and OAOA. Also, it prevents misuse of company powers. It operates even when actual knowledge is absent. What are the criticism of the doctrine? So the doctrine is often criticized because it is harsh on outsiders. It imposes an unrealistic burden to check lengthy documents. Also, it may lead to injustice, especially in modern business transactions. These are the basic criticism of the doctrine. Now, we'll also discuss about exceptions or limitations of the doctrine. Uh, So, to reduce hardship, court developed the doctrine of indoor management, which states that outsiders are not expected to know internal procedure. They can assume internal requirement are compiled. So that is this. Also, the doctrine of constructive notice serves as the protective shield for companies, ensuring that outsiders respect the limit laid down in MOA as well as AOA. However, due to rigid nature, it is balanced by doctrine of indoor management as well, so which protect bona fide outsiders from internal irregularities. So that was it about Unit 3. Now give me a moment. We'll just start a Unit 4 in a minute. Okay. Now coming to Unit 4. In Unit 4, we will discuss about prospectus. So, starting with the meaning of prospectus. Well, a prospectus is a legal document issued by a company to the public, inviting them to subscribe to or purchase its share or debentures. So it contains true, complete, and material information about the company so that investor can make an informed decision before investing. So I'll frame in simple terms. Our prospectus is an invitation to the public to invest in a company along with full disclosure of relevant facts. Okay. Now, what is a legal definition which was given in Companies Act, Section 2 of 70? It defines prospectus means any document described or issued as a prospectus and includes a shelf prospectus or any notice, circular, advertisement, or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. So, this is a legal definition. There is no point of understanding this. You have to learn this definition. If a question is coming on prospectus, you need to write this legal definition. Now, coming to the key elements of the definition. So, what are the things we got to know from definitions? What are the elements in prospectus? The first thing is it must be a document. Then it must be issued to the public. Then it must invite public to subscribe or purchase securities. Then it includes not only a formal prospectus, but also what things? The advertisement, the notices, as well as circulars. So these are the elements of definition. So if a company publishes an advertisement stating that apply now for equity shares of ABC Limited. So, and provide detail about a company and the issue. Such advertisement may be treated as a prospectus under a law. So, that is a prospectus. Now, what is the purpose of prospectus? First thing is to inform investor about the company, then to ensure transparency and full disclosure, also to prevent fraud and misrepresentation, then to enable investors to assess risk and returns. Then talking about the importance, so it acts as a source of information. It serves as a basis for investment decisions. Then it create legal accountability for misstatement. Also, it protect public interest in capital market. So all in all, what can be said about prospectus? So a prospectus is a vital corporate disclosure document basically which bridges the gap between a company and prospective investors by providing complete and truthful information. It is governed strictly by Companies Act 2013 to safeguard investors from deceptions and frauds. So that is all about the meaning, definition, content, importance of prospectus. Now the next thing what we're gonna discuss is misstatement. 1 minute. Yeah. So we'll discuss now about misstatement in prospectus and what are the consequences of misstatement. So first of all, let's understand the meaning. So a misstatement in prospectus occur when a prospectus contain an untrue or a false statement, or it omits a material fact. That is, it does not contain. So whether the information is wrong information is there or something is missing from the prospectus, then it will lead to misstatement in prospectus. It is termed like that. So under the Companies Act 2013, the investor rely heavily on prospectus to decide whether to invest or do not invest. Therefore, the law impose a strict liability for any misstatement. Now, what are the list of what, or you can say what are the features which can be considered as misstatement? The very first thing is it is false, then it is misleading, then it suppresses material information, then it gives half truth that create a wrong impression. So all these things constitute misstatement. Few examples I'll tell so that will be more clear. Let's say claiming that a company has earned profit for the last 5 years when it has actually suffered losses. So such kind of a statement will come under misstatement, or stating that a contract is very profitable without disclosing heavy liabilities, or omitting the fact that company is involved in major litigation. So all these are kind of misstatements. Clear? Now, there are two legal provisions. One is Section 34 and one is Section 35. Section 34 deals with criminal liability for misstatement, whereas Section 35 deals with civil liability of misstatement. Now, the consequences can be divided into civil liability, criminal liability, and remedies available to investors. Talking about civil liability, that is Section 35. So, who are the persons liable under this? The first one is director at the time of issue, who was the director of the company at the time of issue. Then the promoters, then the person authorizing the issue, as well as the expert if a statement relates to them. So these are the persons liable under civil liability. Section 34, 35, sorry. Yeah. Now, nature of liability. So the investor who have suffered loss may claim compensation, or liability arises when if the misstatement was unintentional. So this is this. Now the next thing is criminal liability, which is section 34. So issuing a prospectus containing misstatement with fraudulent intent come under criminal liability. Now there is imprisonment up to 10 years, also fine up to 3 times the amount involved, or both. So if a fraud involves public interest, minimum imprisonment of 3 years may apply under this. And every person who authorized the issue of prospectus will be held punishable under this. Now, the important thing is, what are the remedies available to investors? So the first remedy is rescission of contract. That means investor can cancel the contract and recover money. Then available only if shares are still held, or there is no undue delay, or there is no affirmation after knowing misstatement. Next remedy is claim for damages. What can be done? You can claim for damages. That means investor may sue the company for compensation for loss suffered. Also, there are types of misrepresentation in prospectus. What are these types? The first one is the fraudulent misrepresentation, which can be explained as intent to deceive. Next is negligent misrepresentation. That means lack of reasonable care. And innocent representation, which means honest but incorrect statement. So three types of misrepresentation are there. What are they? Fraudulent, negligent, and innocent. Fraudulent, that means where intentionally you have deceived. Negligent, that is a lack of reasonable care is there. Whereas innocent, the third one, it is honest but incorrect statement is being provided. So these are the types. Okay, there is this small topic under this prospectus unit, a red herring prospectus. This is important from a short answer point of view. So let's understand the meaning. So a red herring prospectus, known as RHP, is a preliminary prospectus issued by a company proposing to make a public issue of securities which does not contain complete particulars of a price or quantity of securities. So it is basically issued before the final prospectus to gauge investor interest and demand in the market. So you can say that before the final prospectus is being released, the initial preliminary prospectus, or the initial mm, prospectus is being released, which is termed as red herring prospectus, and all the informations are not there. Okay, in red herring prospectus. And what is the purpose of red herring prospectus? That means to evaluate what is happening in the market, what are the what investor are interested in, and what is demand in the market. So accordingly, they can make changes into their original final prospectus. So basic or and also it carries a red disclaimer also on its cover page, stating that the information is subject to change, hence the name red herring. Okay, clear? The difference between prospectus and red herring prospectus?
Yes, ma'am.
Great. Now, there is a legal definition also given in section 2 of 70 about red herring because it is important. So, do mention the legal definition as well. So, a prospectus which does not include complete particulars of the quantum or price of the securities included therein. So, this is the legal definition. You will get in your notes all these things. Now, there are the what are the basic features of this prospectus? The first thing is it is issued prior to final prospectus. Then it does not mention issue price or total number of shares. Also, it contains detailed information about it do contain some complete information like the business of the company, then financial statements are there, risk factors are there, management and promoters are mentioned. So these complete informations are there, but the issue price and total number of shares are not being mentioned. Also, it is filed with the registrar of company, so it is not a informal document. Again, it is a formal document which is being registered to the registrar of companies के पास it is filed before the issue opens. So that is this about red herring prospectus. If a long answer is coming, you can write about the difference between a prospectus and a red herring prospectus also. So like that, you can also lengthen your answer. Okay. Yeah. Next is a statement in lieu of prospectus. So a statement in lieu of prospectus is a statutory document filed by the public company with the registrar ROC when the company does not issue a prospectus but allot share privately or does not invite the public to subscribe to all securities. So it serves as a substitute for a prospectus, ensuring disclosure even when no public invitation is made. Now, what is the purpose of statement of lieu of prospectus? So, to ensure minimum disclosure even in private allotments, then to protect investor and members, then to maintain transparency and regulatory oversight, also to inform the ROC about the company's financial and managerial position. So, that is a statement of lieu of prospectus. That is, a statement in lieu of prospectus is required when it is a public company and it does not issue a prospectus. Also, it proposes to allot shares or debentures. Also, one important thing about this that private companies do not required to file this. Only public companies are required. Now, what are the contents are there in a statement? What generally it constitute? The first thing is it constitute the name and registered office of the company. Then details of directors and promoters are there. Then minimum subscription, also shares and debentures issued otherwise other than cash. Then preliminary expenses, particulars of contract, auditors and directors detail. And lastly, it contains commission or the brokerage what is being paid. So all these information it constitute. Now, what are the filing requirements of statement? So it must be filed with ROC at least 3 days before allotment, and it must be signed by all the directors. and it has to be filed in prescribed form only. Now, what happened if there is a non-compliance of a statement of lieu of prospectus? Allotment without filing the statement is voidable. Director may be liable for penalties, and company may face regulatory action if they do not if there is non-compliance of this. Okay. Now, the last topic of this unit is certificate of commencement of business. Well, the certificate of commencement of business is a statutory declaration that authorize a company to start its business operation and exercise its borrowing powers after incorporation of the company. It is merely obtaining the certificate of incorporation does not entitle a company to commence business, but it acts as a legal permission to begin business activities. So, under Section 10 A of Companies Act 2013, a company incorporated after 2 November 2018 and having share capital shall not commence business or exercise borrowing power unless a declaration is filed and with the registrar of companies, and the company has a registered office as per section 12. So these are the legal provision of to have the certificate. And what is a declaration requirement? Well, a declaration must be stated that subscriber to the memorandum have paid the value of shares agreed to be taken, and the company has compiled with provision related to registered office. And there is also a time limit for this. So the declaration must be filed within 180 days of incorporation only. Then only the certificate of commencement of business will be issued. Now, where it is applicable to public companies, to private companies, to OPC, that is one person company. Okay. So all three places they are applicable. Now there are list of companies who are not required to obtain it. Who are they? So companies without share capital, they do not require this certificate. Then companies incorporated before 2 November 2018, they do not require this. Also, there is a penalty if you do not issue this certificate. What is the penalty? Basically, if you fail to file the declaration, a penalty of rupees 50,000 on the company is there. Then penalty of rupees 1,000 per day on officers in default, and maximum it can go to 1 lakh. ROC may initiate action for removal of company's name from the registrar. So these are the penalties in case of non-compliance of this certificate. Okay. Now, we have discussed about two certificates in this unit. The first, in the previous unit 2, we have discussed about certificate of incorporation, whereas here we are discussing certificate of commencement of business. So, what is the difference between two? So, the first difference on the basis of purpose, certificate of incorporation create the legal identity of a company, whereas certificate of commencement, they allow business for operations. And for certificate of commencement, it is compulsory that you need to have certificate of incorporation. So you can say certificate of incorporation is the first step and certificate of commencement is the second step. Also, certificate of incorporation is mandatory, is compulsory for each and every company, whereas certificate of commencement is only for companies with share capital. The companies which do not have share capital, the certificate of commencement is not required. So again, a difference could also come in examination regarding both the certificates, the certificate of incorporation and commencement. So this way you can write. Okay, so that was all about MOA, AOA, and prospectus. Probably in the next class, we will discuss about the upcoming units and try to finish off all the units in the prescribed time format. So if any doubts are there, anything you need to ask, I am providing my email ID in the chat box. You can put me an email for any queries or any doubts. After the completion of the classes only, I'll share the notes. So don't ask in between again and again. So that's all for today. We will meet on upcoming Saturday and Sunday, same time, same link, company law class. Clear?
Yes, ma'am. Thank you, ma'am.
Welcome. You can unmute and talk. Itni der se from past 1 hour, I am just speaking like a fool and I am not getting a single yes from you people. Still, you are typing in the chat box. You can unmute and talk to me.
Yes, thank you, ma'am.